You're listening to Autumn on the Air, the weekly podcast that brings you conversations about the impact of research commercialization and the people who make it happen. Join us for interviews with patent and licensing professionals, innovators, entrepreneurs, and tech transfer leaders on the issues and trends that matter most. Keep listening for an inside track on the people, IP policies, and politics changing our world.
Welcome to Autumn on the Air. Today, we're thrilled to be joined by Dardani, Director of Physical Sciences and Digital Innovations Licensing and Corporate Alliances at Duke University. Dan brings over 20 years of expertise in technology transfer, having spent nearly 2 decades at MIT's Technology Licensing Office before joining Duke. Dan is a certified licensing professional and an internationally recognized leader in software licensing, artificial intelligence, and digital innovation. Dan also serves on the board of directors for Autumn and has chaired Autumn's software course committee for over a decade, helping shape best practices in this ever-evolving field. Welcome to the podcast, Dan. Really excited to have you on the show today.
Thank you for having me. I'm thrilled to be here with you.
Well, I'm excited. We're going to talk everything software licensing, AI, and digital innovation. So I thought the best place to start the podcast is for tech transfer offices, as you well know, Dan, deciding between patenting and copywriting software can be really tricky sometimes. Talk to us a little bit about how you approach this decision at Duke and some of the key factors you consider.
This is an excellent question and a great way to open the podcast that you don't know how often I get asked this, Lisa. I guess the first thing to understand is that patents and copyrights aren't mutually exclusive. They protect different aspects of the software. Copyright protects the literal expression, the code itself, while patents, they protect the underlying function, the innovation, or perhaps even a method. So software comes with copyright right out of the box, as I like to say, because copyright is one of those automatic rights that exist upon fixation, saving your work, for example. Patents are famously more difficult and expensive to obtain, and recent court decisions have made it trickier, or at least less predictable, to get patents on software. But it can be done, especially if you focus on the system, the complete package, or the story that your invention adds. Also, if that invention can be seen as transformative to the subject matter, applied in a non-abstract way, these are all things that are going to help your case. But let me actually answer the actual question you asked. So when we're evaluating whether, software, whether copyright or patent, some factors to consider include, I guess, first and foremost, what's the innovation here, right? Is this an inventive algorithm? Is this a novel system? Or is it something more akin to like an app that just delivers a user experience, wrote code that just does brute force calculations? So understanding like what is the actual thing is probably the question number one. But then there are other factors like what's the technical novelty. Is it a true leap of imagination, or is it just something that's a little bit more incremental? If it's truly a leap, something transformative, that's going to be better than if it's just incremental, because the world may have already moved on before the patent office has reviewed your application. We call this kind of like resource versus runway. Because software moves fast, is the value of your thing near term? Maybe we have to look at copyright plus license strategy that makes more sense than playing the 5-year-long patent chase. I think another variable that I often will think about is whether or not it's a good case for a patent itself, patent eligibility. This is the Section 101. We live in a post-Alice world where we have to be really careful about trying to file on inventions that might be considered an abstract idea. So to avoid that, sometimes you have to tell a story, a compelling story, or emphasize, again, the transformative nature of the technology, rather than just simply showing some isolated performance bump. I think another variable to consider is enforceability. I often call this the does it leave a trace test. Remember, a patent is a right to exclude or prohibit others from making, using, or selling. If your thing doesn't leave a trace, or if it doesn't leave any indication that it's being used because it's deeply embedded, then how will you know to sue someone over it? So, some algorithms are so undetectable that absent sort of a whistleblower or some smoking gun architectural plan, it's going to be really hard to enforce that patent. And so what's the value of an unenforceable patent? So the last one I think maybe to consider is the commercialization strategy, right? If you have a company or a startup that has spun out, that's waiting on this IP license from the TTO in order for them to get launched or to get going, then having a patent, even a pending patent, can be helpful to that company's commercialization strategy. And so having a licensee on the line who will pay for the patent expenses as part of their license is often enough for a licensing manager to proceed with patenting a software algorithm, sort of running the experiment. Even if the patent office is going to have some hiccups on it, it's still worth running the experiment knowing that you have a licensee that's on the hook waiting for it.
Now, Dan, I want to stick on software patents for a second, because as you well know, the USPTO has some strict guidelines for them. And you mentioned some of the challenges like subject matter eligibility in Section 101. Can you share some examples where software innovations successfully met these criteria?
Oh, yeah, there are lots going all the way back to like Diamond v. Diehr in the early 1980s. That one had to do with software controlling the rubber molding press, right? And it's one of those cases that when you sort of read it, it brings up this key word, transformative, which is a key concept in IP thinking. Transformative is kind of like a magic word in the IP courts. You always want to claim that your work is transformative on some level. But, the idea being that if there is a way of having not just a sort of mathematical calculation, but a tool that can actually make an imprint or an effect in the world, tangible, practical, concrete application, then you're more likely to potentially get that software algorithm approved. After that, we'd have things like the State Street decision and, Amazon's one-click patent, although those are getting pretty old now. But those, were sort of other examples where, it met the eligibility for software to be patented. Nowadays, in a post-Alice world, we have to be a little bit more careful about how we apply for algorithms. Again, emphasizing the applied nature of it and sort of, as I like to say, telling a complete and compelling story. But software patents are still routinely granted for novel applications. I think a good example could be in a general case. Let's say you've got some software that makes a CPU work more efficiently, perhaps closer to like a graphics chip, or essentially turning a CPU more like a GPU. That would be an extremely valuable algorithmic process or system, particularly in a world that's increasingly dominated by AI and machine learning. So that would be something that I think would probably pass muster for the PTO.
So then, looking at it from the flip side, are there specific types of software that you can, recognize right off the bat that you feel are better suited for copyright protection than patents?
Yes, indeed. I guess I would start by saying things that are like rote code, stuff that isn't necessarily clever, but more of a workhorse, is less suited for patent protection, right? Software that might primarily be a user interface, standard data technique, or standard data processing, applications that don't necessarily have novel algorithms are typically better protected under copyright. So smartphone apps, which we sometimes see, just pure database plays, or just standard implementations, I think are some of the examples where there's really not going to be any innovative algorithm that would likely want to rise to the level of running the patent experiment. Remember, copyright really safeguards expression. And so that's going to protect, the way you or the programmer makes certain code or design choices in their software. but it's never going to protect the underlying concept, the idea, or the functionality. So we use copyright in a sense as a sort of first line measure, a shield for just protecting the innovation, the original work that it was produced, the low hanging fruit, if you will.
Now, I want to turn to open source software because that's increasingly common in university research. What are some of the biggest risks tech transfer offices face when dealing with open source code and inventions?
Great question. Open source is vital to software innovation these days. You can't really get around it. I would say some risks that TTOs see when dealing with open source innovations include things like third-party code issues, sponsorship issues, open source license compliance issues, especially the ones that have those restrictive licenses. Like maybe I'll drill down a little bit more about that. So like, for instance, integrating code under one of these copyleft licenses, the viral kind, like the GNU GPL, they can require the release of your proprietary code downstream, particularly if you are modifying and then distributing the underlying GPU code with your modifications. So it's important to not also inadvertently commit copyright infringement by releasing someone else's code, right? Masquerading or hiding in your own code, because oftentimes programmers will borrow bits and pieces or see things solved in others and, incorporate that into their own larger code sets. So, those are things that you have to sort of be cognizant of. Also, checking to make sure that the thing being released wasn't sponsored, primarily by industry, right? Because industry sponsorships generally come with certain license rights or expectations for that deliverable or for the results of that sponsored project. And open source licensing, directly giving it away to the entire public world for free, can, sometimes usurp whatever was in those sponsored research agreements. So understanding whether or not there were sponsors for the code before it's just broadcast out to the world is an important thing to do. Again, know if your code itself is making use of other open source code, because each open source code has its own restrictions or permissions. So if you're linking it to permissive licenses like the MIT license or the BSD license, you're generally going to be fine. There's no problem. But there are going to be other licenses like the GPL that have these required share alike terms, or even some of them open the door to automatic patent grants to really broad patent portfolios within your university that, you should really be mindful of.
Absolutely. So then I want to move on to a kind of a delicate question about balancing researchers' desire to use open source licenses. How do you balance that with the university's need to protect IP and pursue commercialization?
Yeah, it's a great question. Again, balancing, the interest requires, I think, education and early communication. The way it's generally worked is the university will not ever really veto a researcher's request to open something, even if they thought perhaps there was commercial value to be gotten out of that innovation. If the originator of the work has a desire to release something openly, then I feel it's the licensing manager's job to facilitate that and otherwise make that happen. But there's a component of this where you can educate those researchers to understand like the different kinds of open source choices and their impacts, right? So the first thing I always try and impart is that open source is a brand, not a concept, right? And most people misuse the word open source and they conflate it with just making things publicly available for others to use, generally online. But there are many ways to release code to the public, and open source is only one way. In fact, it's, as I said, based on the Open Source Foundation. There are other types of vehicles for getting things out into the world, like Creative Commons, or even bespoke tech transfer office licenses from your university. You can literally draft a license that says we're making this code available under the terms X, Y, and Z. And that would be, essentially a university release agreement. So when researchers get educated about like these concepts and the implications of the various licenses that they can select, they can make more informed decisions that align with their goals. For example, in the case where, there might be a desire to commercialize, but also open source, you can deploy dual licensing strategies. This allows for both the open source distribution to say like the research and the academic community, while preserving commercial and proprietary rights for any potential monetization plans.
Now, Dan, would you be able to share a success story with us where open source licensing played a pivotal role in a technology's commercialization?
One that immediately comes to mind is one I worked on before coming to Duke. At MIT, they had this engineering software, FFTW, which stood for Fastest Fourier Transform in the West. This was signal processing software for calculating the discrete Fourier transform, which helps with analyzing frequencies for various time-dependent functions. Don't worry, we're not going to get into the math. I don't want people's heads exploding out there.
Exactly.
We were told there would be no math on the podcast. So anyway, what matters is that FFTW as a code base is made freely available to certain constituencies under that GNU GPL license we mentioned a minute ago. That's the copyleft license, the viral one that says like everyone else that uses it, everyone downstream has these share alike requirements, right? And so that's fine for many, like an academic or a researcher that's just using this tool for an academic project. But for some, say, companies, enterprise businesses, they might want to use this software without these restrictions. So in those sense, commercial licenses were offered for them for a fee. And last time I recall, that code would get licensed dozens of times each year. By now, probably hundreds, if not thousands of times, earning large sums of money in aggregate. Lots of zeros after the numbers in total licensing revenue brought in over time from this sort of hybrid licensing.
That's really incredible. So I want to turn and ask, what do you advise when your faculty and researchers have to release their code as part of the peer review publication process?
This is a juicy one.
Yes.
So much confusion about this matter,
yes.
Right? Funding agencies and journals will often ask, if not actually require, that like the accompanying software and data be made freely available, publicly available as a condition for should they be, funded or given the grant, or as a condition of them publishing this article in their publication. So absent any specific requirements or instructions from, say, the granting agency or from a journal, oftentimes the specific details for how to release your software or data are left up to the researcher, or perhaps to say to the university, to determine and comply. And this is where experience and advice can be helpful to your researchers, because they might be unsure how to proceed. They might have other objectives that they wish to preserve for their work. So you don't want to just, throw the baby out with the bathwater simply because you want to get something published. So what we generally do is we provide them the different options for complying that can generally satisfy the obligation up top, but still protect these other objectives or goals, like, for example, reserving commercial rights for potential licensing, or, if there wants to be a startup down the road to commercialize this, there could be an opportunity to make sure that commercial licenses to that startup are still present. So what we mean by options is, it could just be as simple as picking the right license, right? We mentioned a couple of different flavors of open source license, and there are different flavors that allow you to release something without necessarily forfeiting or giving away commercial rights. There also is the ability to only make available snippets of the full code or the full data set. So you're not really releasing anything to anyone, still allowing for scientists to follow along, double check what is in your publication in terms of results, reproducibility, the scientific method and all that, but not giving any enough for commercial copycats to potentially usurp or do anything nefarious without your permission. You could also release pseudocode, right? That's kind of like a digital cousin, not necessarily a digital twin, but a digital cousin that says, this code is just as good as the one that we used, and you can use this to reproduce my results in the paper. You could also adopt synthetic data, where you're not really releasing the full actual data, but you're releasing a synthetic data set that mimics or otherwise works similarly to reproduce those results. So it's important to get guidance, I think, from your tech transfer office as to, which of these options may be best for you, because, the software is an important piece beyond patents for, translating your research to the market. So we don't want we never want to get in front of publishing. And we understand that at the end of the day, at a university, everything needs to be published. So the idea is, how can we sort of work cleverly and collaboratively to achieve both goals to the best of everyone's wants?
Well, Dan, that's been a great discussion on software and software licensing. So now I want to turn a little bit and focus on machine learning and AI, which is obviously a very, very hot topic and is going to be for a long time. So as you know, AI models often rely on data sets for training, and that might not be owned by the university. Talk to us how you at Duke address IP ownership issues when working with these technologies.
Absolutely. Provenance certainly helps, right? Focusing on doing due diligence on who owns that data. I had a former colleague at MIT, Myron Kasaraba. He used to say, is your organization a data producer or a data user? And I think understanding the answer to that question helps sort of drive what next steps are in terms of your due diligence. If you are using other people's data, you better find out its backstory. Is that data public? Are you sure? How sure? Data just published on the internet is not the same thing as it being freely usable. Are you licensing the data? Are you scraping the data? Find out what the source has in terms of any obligations being imposed on downstream users, because you may have to actually carry through to use it, et cetera. So what I would also say is the type of data also matters, right? Is this just numerical data, like the kind from a sensor or a meter, like let's say the thermometer on top of a building that's measuring temperature every day? Or is this more sensitive data? Patient data, protected health information. What laws and regulations govern that data? These can vary greatly by institution, by organization, even by geography. So it's crucial to understand the various layers and document these data sources, obtaining, whatever permissions you might need, whatever consents you might need to avoid getting into trouble. Especially when the perhaps AI model or tool that you're trying to feed this data into is intended for commercialization. But, honestly, we can have a whole entire podcast just on this one issue.
Yeah, huge issue. And actually, another really fascinating issue relating to machine learning and AI in particular has to do with inventorship. And I think we all know the Federal Circuit and the USPTO has stated and ruled that AI cannot be listed as an inventor. So how do you navigate this situation when inventorship questions come up where AI plays a significant role in generating either the new idea or maybe even the solution, or maybe both?
Yes, well, AI can assist in the inventive process, we like to say, but current laws require a human to be named as the inventor, right? The courts are clear on this. Unless Congress acts to change the statutes, IP laws are applicable to human beings. So this means, copyrights are not afforded to selfie-taking monkeys, as we learned from
yes.
The Naruto case.
Yes.
And And patents are not granted to devices for autonomous bootstrapping of unified sentience or DABUS. So I think, the reality is AI is already and will continue to play a hugely significant role in, the development of technology. For the moment, the AI is part of the actual subject matter or claims of the patent, but it's the individual who either used that AI or directed the AI's use in a meaningful way that gets listed as the applicant. And I think as long as you stick to that, you'll be in compliance with whatever our current USPTO guidelines, until which time perhaps down the road they start to look at it differently.
Yeah, absolutely. And we'll see. It's continuing to evolve. And, that leads me to ask you, sticking on patent laws and AI, how do you think they need to evolve to accommodate all these AI-generated innovations?
Yeah, again, there's no question, evolution is going to have to happen, right? As AI becomes more integral to the inventive process and to the world in general. And by the way, the USPTO also uses AI tools,
yes,
right?
A lot of them
to help with its patent examination process. So the patent laws, I think, are going to need to adapt to, address questions of inventorship, ownership, and what's the definition of non-obviousness in the context of AI-generated outputs. There's an analogy that I sometimes use to, I think, describe where this might be going. But, copyright is given to authors of works. And if you are a photographer, you certainly are the copyright owner of the photographs you take when you sort of push the little button on your camera. But nowadays, modern cameras are getting pretty cool in terms of all like the software tricks and techniques that are baked in. And yet that photographer gets a copyright the same way, which is one click of a modern camera on an image with all these enhancements, improvements that are sort of going on behind the scenes to make that photograph look better or, compensate for shadows and all this other thing. In the same vein, I think IP will need to expand and accommodate AI and machine learning tools that are assisting humans in the loop too. Because on some level, what's the difference between me sort of going to an LLM and asking it to help me produce something where, yes, clearly it's got some tools to assist, than the photographer who's pushing that button and having all these tools assist in the composition of that image photograph? Like, copyright seems to be fine for him, but yet I can't get copyright on me just because I asked ChatGPT to help. So I think ongoing and forward thinking and perhaps, future-proofing policy developments are going to be crucial in this area.
Yeah, it's going to be fascinating to watch. I mean, as it continues to evolve and new legal issues come up all the time. So stay tuned on that one. So Dan, I wanted to ask you, with tools like GitHub Copilot generating code that might infringe on existing IP, what advice would you give TTOs to help try and mitigate some of these risks?
Well, arguably, the output from an AI agent isn't copyrightable for the reasons we've just stated. Whether that helps in a potential infringement claim brought by a third party is a different question. I don't know. I'm not an attorney. I just play one on TV. Infringement of copyright really requires both access to the original work and then, a measure of substantive similarity, which is a subjective test. In the case of like Gen AI producing code, the argument would perhaps be that, from the sources it scraped to train and learn how to generate the code, that was the infringement. But I think that's a more complicated case because it involves kind of more than one plaintiff. And I could see issues with standing, who has the right to bring the suit when, there's all these different folks whose information has been scraped in order to train the LLM how to code. Anyway, I would, punt on all of that. So the best advice I have is it starts with a clean house, right? So tech transfer offices should already have clear, software disclosure guidance and policies that require researchers to self-report or vet their software disclosures for any third party or AI-generated code or other potential IP issues. Again, we've talked about this concept of provenance, but I can't stress that the importance of that enough. It's an important part of your job is just clearing sort of the backstory. And there are tools that you can use these days to help track code dependencies that help with mitigating infringement risk. But each TTO is going to have its own sort of ability, whether or not they can afford or have the resources to adopt those tools. But always remember, another tried and tested solution is very simple. Just remove the parts of the code that are questionable. That's it. Simply rewrite them. Excise the bad stuff and start over. The bar for originality is low in copyright. So writing a new routine or a new module with a modicum of originality is one way to ensure, you avoid this and have a smoother path ahead. Yeah.
Great answer and advice at the same time, and really nice job punting on it. That was a great recovery there. So really good. So Dan, how can universities prepare for the demand for AI innovations as well as adapt to growing requests for their data that's so important to the field of AI?
Again, it helps to distinguish between the types of data being sought for licensing. We talked about like standard data sets, like a sensor data, non-PHI data, the de-identified collected information, numerical data. Those are, for the most part, handled using fairly straightforward data use agreements. And tech transfer offices and licensing managers, should be pretty familiar with that. But there are other data sets that require a more involved process. And certainly at Duke, we see a growing demand for data derived from human sources or patients, like the kind in our hospital and in our clinics. And approving that involves a more rigorous sort of multi-stakeholder review process. The idea or the goal is essentially to make sure that we can disseminate this data responsibly, following all the rules, of course, safeguarding privacy, but, equally not just saying no. I think universities that are willing to roll up their sleeves and get down to work to sort of, thrive in this new world will position themselves to do better than those who can't or won't see a path forward simply because of organizational inertia or their tried and tested default to no because of low risk tolerance. And here I think Duke's kind of leading the way, right? Because Duke does do commercial licensing of data to third parties. The de-identified clinical data collected by the medical school or by its health system, all that's on the table. And Duke even has a policy for how to affect, licensing human source data. They even have a data licensing committee that they've created that's made up of senior stakeholders and other university leaders who get together to review and vet these data licensing requests and resolve any issues. So they're being really proactive, and perhaps because of where Duke sits uniquely, with, an AI generating engineering school, co-located with a world-class medical school, co-located with an actual real seeing patients health system, all sort of grouped together. So it makes sense for them to be sort of thinking about how to go from, lab to patient in the easiest way possible.
Absolutely. Completely agree with you on that. And, Dan, this has really been a great conversation. I want to ask you one last question, though, and that is, what advice would you give to tech transfer offices that are just beginning to think about these issues and develop policies around proper software innovation, hygiene, and AI-related inventions?
I think it helps to stay nimble, is what I would say. The field is moving fast, and tech transfer offices and perhaps even general counsel offices that are agile will likely fare better. Start with building a solid foundation. As I said, develop clear guidelines for your invention disclosure processes of software and AI IP. Have a position on open source so that you can offer outreach to your PIs so that they're not just flying blind or acting alone without any guidance. Establish those relationships, build trust with those researchers so that they come to see the tech transfer office as a value add, someone who helps them with answers and results and not just seen as a bureaucracy a compliance checkbox, or worse, like some kind of impediment to the innovative process. And I guess what I would also say is TTOs don't have to really do this alone. Before joining the board at Autumn, I was a longtime member and chair on the software committee for many years. And one of the things that committee was responsible for producing was we would do these regular 2-day workshops, these courses to teach best practices and to make resources available to folks and to establish open dialogues on things like follow-on e-groups and online chats that would always be, specifically geared towards this space, towards software, towards data, towards open source, towards AI. And all of that would help demystify the sort of software and digital IP process. So I would encourage TTOs that are understanding or recognizing now that they need, to get with it and establish some programs to lean into all that help. And I guess if all else fails, contact me and I'll see how best I can help or steer you in the right direction.
That's awesome. And that's some great advice. So thank you very much for that, Dan. And, thank you for being here today. Any final thoughts you'd like to share with the audience?
Well, first off, thank you, Lisa. This has been a real pleasure. I guess if I had to leave the listener with one thought, it's this. Software is eating the world. It's also changing how we approach protection and sharing and commercializing innovations. And, it's folks like, the software tech transfer professionals, we're not just riding this wave, we're actually shaping and steering where it lands. And that's pretty exciting, at least to me. So I guess whether you're puzzling over making sense of AI innovations, wrangling with open source questions, or just trying to work out how to keep the deals moving forward in this area, remember, we're not just doing deals for a numbers games, we're actually helping civilization level up. So I guess stay curious, collaborative, and maybe caffeinated. So thanks again for having me. This has been a lot of fun.
This has been great. Thank you so much, Dan.
My pleasure. Enjoy the rest of your day.
Dan, thank you so much for sharing your deep expertise on these critical topics today. Your insights into software licensing, open source compliance, machine learning, and artificial intelligence have been incredibly valuable. For those of our listeners who want to learn more about Dan's work or connect with him directly, visit Duke University's Office of Technology Commercialization website at otc.duke.edu. If you enjoyed this episode of Autumn on the Air, don't forget to subscribe, rate us, and share it with your colleagues. Join us next week as we continue exploring the world of research commercialization and its impact on innovation worldwide. Until then, keep innovating.
Thanks for listening to Autumn on the Air with Lisa Mueller. Get social with us and share your thoughts. You can tweet us at AUTM or visit us online at autm.net. We'll be back next week on the air. Be sure to join us.